I'll call the next case on the 9 a.m. docket, State of Kansas versus John Boese, case number 125691. Counsel, you may approach.
Good morning. May it please the court, the appellate petitioner, State of Kansas, appears by Stephen Obermeyer. I'm an assistant solicitor general. And the issue for the court this morning on petition for review is whether harmless error can ever apply to an alternative means error in a complaint filed in.
This is what's befuddled me about this.
Okay.
How is it an alternative means problem? Because always before, we had the defendant being charged with multiple means of committing the same crime. You didn't do that. The state didn't do that in this case. They charged this defendant with one means of committing the charge. That's a whole different problem, it seems to me. So to me, it's not even an alternative means issue, because that was trying to figure out whether, a jury, and this doesn't even have a jury to it, but a jury convicted of one possibility versus another possibility when the jury was instructed on both of those possibilities. We don't have any of that here. So just because it's an alternative means problem, it seems to me what you're trying to do is say, well, we could have charged two different ways. We didn't, but now we want to go back and charge after we've had a trial. I don't even see how you characterize this as an alternative means problem. So start with that basic.
Sure. The violation of a protective order statute there's 6 different ways a protective order can be violated. And the two at issue here is subsection A1, protection from abuse order, and subsection A6, a protection from stalking order. And the complaint charged the defendant with violating a court order filed in the District Court of Marion County, Kansas, where it states the defendant sent messages to his mother, whom the protected person, the victim, is residing with, the same being in violation of a protection order. The problem was the to-wit alleged was mistaken. It alleged he violated a protection from abuse order as opposed to a protection from stalking order. And I think that the case proceeded to try. The defendant was present when the protection order was issued, number one. The case proceeded to trial with nobody being confused about the fact that he was charged with violating a protection from stalking order. It was referenced in opening statements. The defense counsel cross-examined the victim about the protection from stalking order, argued the protection from stalking wasn't violated in closing arguments. And the district court recessed to deliberate and looked at the pattern instructions, which has the 6 different options, and said, I find the defendant guilty of violating a protection from stalking order. So to the effect we have a general verdict versus specific verdict issue that State versus Wright created, we don't have that. The judge said, I find you violated the protection from stalking statute. I think the issue is really the variance in the complaint. If you don't see the complaint as being broad enough to encompass that he violated the protection from stalking, the variance from the alleged protection from abuse order and the protection from stalking order. And there are cases, well, in State versus Reynolds, this court talked about.
In State versus Reynolds, the defendant was charged with both burglarizing a building and a dwelling. So those two things were charged. And when we got, toward the end of Reynolds, the state wanted to say, well, this is a charging document problem, and we analyzed it from there. But that's not the same thing as what's happening here. You're substituting a whole different set of facts that create a crime that weren't charged. The example I can't get out of my head with this one is the one that I always have with alternative means.
Okay.
Sodomy. Because you can commit sodomy, with a person or with an animal. And let's assume the state charged someone with sodomy with a person. Everybody knew the case was about bestiality. And you're trying to say that at the end of the day, you can convict someone of sodomy, bestiality under the sodomy statute, even though you charged it with a person. That doesn't make any sense to me. And it's the same thing,
Okay.
I think.
I think I'm not sure what the complaint alleged in your example, but if it didn't allege the bestiality option.
Yeah, it doesn't, but
Okay.
your complaint doesn't allege the other option.
Okay.
That's why I just don't even understand the premise.
Okay. I would direct the court to State versus Turbeville, which talks about issues where the complaint is essentially broadened beyond what is alleged in the complaint. And if the case proceeds to trial, and the evidence of the bestiality is admitted, and there's no objection to that instruction, then we have a variance issue where the complaint is essentially broadened. And the court in Fitzgerald says that those aren't issues that we've addressed. We've not argued instruction error, constructive amendment, or variance. And in your case, Justice Biles, I think the analysis would be, was it clearly erroneous to instruct the jury on the bestiality alternative means that when it wasn't charged? And I think you'd look to the harmless error statutes, the 60-2105 and 6261 and the 22-3414, and say, and consider whether the substantial rights of the defendant was violated when the complaint was, when there's a variance in the complaint and it was broadened to include that.
Go ahead. So following up on that, I guess the question I keep having is this even a substantial competent evidence or a sufficiency of the evidence case?
The Court of Appeals considered it as a sufficiency.
Right, but is it? I mean, there is no dispute at all, as far as I can tell, and it's not a jury trial, it's a trial to the bench,
right,
about the evidence.
Right.
So what do we do with that?
The problem with the Court of Appeals, and this was first time on appeal, because in the district court, defense counsel and Mr. Boese didn't say, I don't know what I'm charged with. I need a bill of particulars. None of that. It's considered whether or not I think whether there's sufficient evidence of protection from stalking. The Court of Appeals said that. I think you frame the issue as, is there a variance in the complaint under Fitzgerald or constructive amendment to do that? And we don't have a jury trial, so we don't have the 22-3414 that might apply. But Reynolds also talks about the 6261 and the 60-2105.
So
harmless error.
As I understand your argument, it's that Mr. Boese was convicted of violating a protection from stalking order. That's the conviction.
And that's what the trial court specifically stated.
Which is why you say that's the conviction.
I'm sorry.
That's the reason that you're arguing that is the conviction.
Yes.
Because that's what the judge pronounced.
Correct.
You don't argue that was not in the charging document. In fact, the charging document charged a PFA violation. I'm just trying to lay the groundwork of that.
Yes.
Okay. And so I don't even think the defendant, we'll see, but I don't think the defendant would claim that if the conviction is for violating a PFS, there's no sufficiency problem here. Right?
Right.
That's your argument. So why are you, this was raised on appeal as a sufficiency claim. Why go into all the other stuff about variances and constructive amendments and so on?
As opposed to
why does that matter?
I was pointing out that what the Fitzgerald court did not consider the variance, and in this case that you had the abundant evidence of protection from stalking. Whether or not that was an option in means or an alternative means.
Let me ask another background question. Was the only issue raised on appeal in this case sufficient evidence?
Under Fitzgerald, that the evidence was not sufficient to be violation of a protection from abuse statute. Yes.
So it seems to me the crucial question is, what was he convicted of? And if he was convicted of a PFS violation, the evidence was sufficient. And if it's a PFA violation, it wasn't sufficient. How is this case any more complicated than that? I guess that's what I'm really trying to get.
I don't think it is, except we had the state versus right and got into the alternative means, option within means, and there wasn't sufficient evidence of the protection from abuse option. And that's why the Court of Appeals said, unless and until until our Supreme Court clarifies Fitzgerald is no longer good law, we reaffirm our prior rulings. And I think in discussing the harmless error statutes in Fitzgerald and pointing out that in State versus Right, that language from State v. Right is dicta, that this should not be a structural error issue. It's whether or not the defendant was substantially prejudiced by the variance or constructive amendment of the complaint when he did not object to admission of the protection from stalking order and knew what he was proceeding to trial. And this was not
I guess that goes back to my confusion about, frankly, the way the state has litigated this case. I mean, the state has brought in a whole lot of quote unquote error issues and talked about harmless error and structural error and so on. But the appeal never even, the appeal didn't claim any errors, did it? The appeal just said there was not sufficient evidence. Am I wrong about that?
That's based upon State versus Fitzgerald.
Well, I'm reading the brief of appellant.
Okay.
And the way the issue is framed is, and sort of goes to both of you, insufficient evidence supported Boese's conviction in that the state filed the wrong crime in its complaint, which is true. I mean, that's
Right.
That's
right.
That's a given. But then it says, and Boese was found guilty of a different crime than what the evidence showed. And that gets to Justice Stiegel's point. And the evidence did show the crime that he was convicted of. So we've sort of got two different things at play here in the way that the defendant has issued. But it is a fact that he was convicted of a crime, of the wrong crime in the complaint. He was convicted of a crime that you did not charge. By definition, he did not commit the crime that you charged in the complaint because you were that specific.
I'm not sure that the crime is.
Whether it matters is a different question.
Okay.
But we can't dispute that this complaint involves a different crime than what he was convicted of. Committing a crime in a way that he didn't do because he did it a different way.
Okay, it's because it's a different subsection. I don't think it's a different crime. I think the crime is violation of a protection order. You can do that 6 ways. It's not, you're charged with forgery and at trial, we find you guilty of making a false writing, like some Kafka-esque trial.
That gets you back to my
was charged with violation of a protection.
That gets you back to my sodomy argument.
Okay, all right.
What do you have to tell the defendant when you want to throw him in jail that they did in order to throw him in jail? And if you charged sodomy with a person and the whole case is about bestiality, that's the problem that has to be unwound. That's all we're trying to do is identify what we've got to wrestle with here.
Okay. And when I get that complaint charging me with the wrong alternative means or wrong subsection, I'm going to get discovery in the case. I could file a bill of particulars. I'm going to have a preliminary hearing. I'm going to know what the evidence is against me. And so can I just sit back not say anything and wait till the jury verdict and say, King's X, you charged me with the wrong crime. And I think that's what 22-30-208 is against. If you find there's a defect in the complaint or if it's deficient, you need to raise that to the court. Otherwise, we'll assume you know what you were charged with and you're proceeding to trial. And certainly in this case, none of Mr. Boese wasn't shocked to find out that he violated the protection from stalking statute.
Can I go back
Please go ahead.
to pick up on the question about what is the crime of conviction, right? Because we've also got a judgment, a written journal entry of judgment that says the convictions for protection of abuse order. So is this a civil proceeding?
No.
Okay, what was your basis for appellate jurisdiction?
Well, the defendant appealed direct appeal from conviction.
Okay, so under the criminal under the right to appeal from a criminal conviction.
Correct.
So even though the PFA proceedings are civil in nature, the violation puts it into the criminal arena. And so therefore your argument is that the pronouncement from the bench controls rather than the journal entry.
Right. And I argued in the initial brief that that's non-protunct material, that the journal entry doesn't accurately reflect what the transcript of the end of.
Well, it aligns with the charging document though, right? So, I mean, if it were to control, like if this were a civil proceeding, the journal entry would control, right? And then you would have a conviction that matched the conviction, and then sufficiency makes sense, right? Then you're testing the evidence against protection from abuse as opposed to stalking.
I can't speak to civil cases, Justice Wall, but if the judge said, I find you guilty of violating the protection from stalking statute, and the journal entry states protection from abuse, I think that's an error that should be corrected. The journal entry ought to be corrected. That's all I'm saying on that. If the judge mispronounces a sentence in court and the journal entry has something different, are we going to go with the bigger sentence in the journal entry because that's what it says? I don't think so. We go with what the judge said at the time of sentencing.
And under Fitzgerald, which was sodomy, and the difference was, let me pull this up. The difference was that the defendant was charged under 5504B2, which was causing a child under 14 to engage in sodomy with any person. But the jury was instructed under B1, which prohibited sodomy with a child who's under 14. The difference being, was it with the defendant or was it with any person? And in that case, we held, that there was insufficient evidence. How is this case different?
The interesting part in Fitzgerald is the jury was not instructed on sodomy with another person under that alternative.
Right.
They found him guilty of sodomy with the defendant. And I think the court kind of struggled with the state versus right analysis, but at the end of Fitzgerald, Justice Beyer writes, the state has not argued instruction error, constructive amendment, or variance, and supported any such argument with statutory law, common law, or constitutional authority. And I think this case, I don't think that it should be a structural error every time if you charge the wrong subsection under the same statute of the same crime, a different way of committing a protection from a.
So would we have to overrule Fitzgerald?
Well, the Court of Appeals wants that to be said, but I don't think you have to say we overrule Fitzgerald. I think you can look at the analysis in State versus Reynolds that.
Okay, let's assume that we don't find this as alternative means.
Okay.
Okay.
Then I think you're into the KSA 6261 and the 60-2105, the harmless error.
For insufficient evidence?
Well,
How can there be harmless error? I mean, Fitzgerald's pretty clear on that. How can insufficient evidence be subject to harmless error?
well, there was sufficient evidence as to the stalking. I think, well,
But
okay.
the argument was there's insufficient evidence of the crime.
And the Fitzgerald court said, we are not considering variance. We're not considering the fact.
So we
that
would
the-
distinguish Fitzgerald by just saying, hey, they didn't raise this variance issue in Fitzgerald, but they raised it here, so we're all good.
I think so.
Is there any other way to distinguish Fitzgerald besides that?
Yes, we have the variance, we have the cases like State versus Turbeville where the charge in the jury and in the instruction or what the court found is broader than what's in the complaint. And Turbeville and cases like that say, if it doesn't violate the substantial rights of the defendant.
How is this broader?
It's broader because he's charged with, he was found guilty of a different subsection of the protection from stalking as opposed to the protection from abuse subsection, which I argued is an option within means. What does it matter to the defendant? What kind of order he violates? The statute says you shouldn't violate a court order by contacting the victim.
What does it matter? I mean, that's the order you're charged with violating. I mean, is it due process issue? You know, you need to know what order you're charged with violating.
And I think Reynolds touches on it, and Griffin and State versus Grissom say it's not a due process violation. It's whether or not the substantial rights of the defendant are violated under the Kansas statutes. And clearly his substantial rights were not violated. He knew what he was charged with.
Any other questions of Mr. Obermeyer? You're out of time. Would you like to quickly summarize? And you did reserve 3 minutes.
I'll just come back.
Thank you, Mr. Okay, thank you. Mr. Whalen.
May it please the court. Michael Whalen on behalf of the appellant, John Boese. Lest there remain any doubt about the constitutional stature of the reasonable doubt standard, we explicitly hold that the due process clause protects the accused against conviction, except upon proof beyond a reasonable doubt of every fact necessary to constitute the crime with which he is charged. In re Winship, United States Supreme Court, 1970. This principle has continued through Kansas legal history. If we look at Haberlein, McClelland, Chapman, all of them say that the charged crime is the crime for which the proof must be set.
What is the charged crime here?
It was subsection A1, violation of a protection from abuse
Well, there are 2 ways to look at it, right? I mean, subsection A just says violation of a protective order is : and then there's a bunch of subsections.
Yes, Your Honor.
So is the crime defined by sub A, violation of a protective order, with alternative means, or is each of those subsections a separate crime?
Each of those subsections is a separate crime.
So your argument is this is not an alternative means statute at all?
Not at all, no, Your Honor. Each one of these potential crimes under the 6 possibilities has a specific actus reus and mens rea. It is about what type of protection order they have intended to violate and knowingly making that action.
Are there different penalties associated with the different subsections?
I don't believe so, Your Honor, but I can't say for sure. I just don't know.
Why aren't they just different facts, each of which independently can support the elements of violating a protective order?
Because if we even look at it and take it from statutorily, how it is written, each one is separated by an and. Each one has different elements which need to be proved.
Yeah,
Not
different.
just an alternative means. It's not a different way of it. I guess it is a different way of committing the crime.
Isn't that
but
what we
each-
say alternative means is a different
But
way?
we're talking about a charging document, not an
Right,
alternative means issue.
I just wanted to understand
Okay.
your perspective on the statute first, and
Yes, Your
before
Honor.
we even get to the documents and so on.
Thank you, Justice.
What prejudice do you claim? I mean, everybody tried the case, knowing
Right.
what they were talking about. It's just the state cited the wrong subsection in charging him. So, I mean, that could create a prejudice. I understand. I'm just saying, do you have any here? There's some defense that didn't get raised, that would have been raised. There was different fact investigation that would have occurred. Something different, other than the fact that everybody knew what they were talking about. It's just the state put the wrong subsection in the charge.
The state has one job. That's to get the charge correct. In this case, and quite honestly, we have no evidence that perhaps this prosecutor wanted to charge this crime, and it wasn't just some mistake. The state has complete authority over the charges of crimes. The power of the state to charge and prosecute its citizens for criminal violations of the law is a fearsome one, and it is vested exclusively in a prosecutor who is given vast discretion to make both charging decisions and the myriad of practical and strategic decisions that occur in the course of a prosecution.
I understand
Yes, Your Honor.
that they had the obligation to do it right. Now, what we have to figure out is what's the consequence of that. One of the things that enters into the consequence is whether the defendant was hurt in some way, in terms of how they would have defended the case, what would have happened. Did they not understand? They showed up for this bench trial wanting to defend against one kind of order, and son of a gun, they're talking about a different order, and the defendant didn't have any witnesses. Something that shows prejudice besides the fact it's their job and they didn't do it.
In those practical terms, I have to agree with you. There was not a set prejudice that came out of this. But this court has held consistently from Fitzgerald and cases beyond. And in State versus Lacey, the Court of Appeals gave a warning to prosecutors when they found insufficient evidence based on an incorrect crime being charged. And they said, this is an awesome responsibility. And when both the judge and the prosecutor miss it, it's a violation. And we are talking here about, I mean, this is a Sixth Amendment issue and the right to notice. And this goes all the way back to English common law, that the prosecutor is charged to present a complaint that shows the charge and what they believe the individual can be convicted of.
Mr. Whalen, as you know, Justice Biles asking about prejudice, and it all comes down to prejudice. But aren't you basically just saying that prejudice is not important in this case because insufficient evidence is not subject to a harmless error analysis?
It's not that the charge isn't subject to harmless error. It can't be harmless error because we are talking about a constitutional situation here.
Right, but you're claiming insufficient evidence, right?
Right. The state did not prove the charge that they filed.
Right, and so has there been a case where we have subjected insufficient evidence to a harmless error review?
No, not that I'm aware of, Your Honor. And
So
this kind of acts.
Can I follow up on that?
Yes.
I mean, it's certainly true that the charge as filed, I guess, if we want to consider the specific subsection, which we should, was not proved. There's insufficient evidence, but that's not the crime he was convicted of. And I'm circling back to some of my earlier questions. So it strikes me that your argument starts out as insufficient evidence and then morphs into a lot of different kinds of errors. whether they're constitutional errors, due process errors, charging document errors under our case law. Am I correct that the reason for framing this as insufficiency is that the state doesn't get a second bite at the apple here? Because if this was raised as just an error, charging document error, or due process or what have you, I mean, this would be remanded for a new trial, right? Even if there was prejudice, if it wasn't harmless, it would be remanded for a new trial.
Well, it can't be because he's already been tried for his supposed crime.
I'm just asking.
Okay, I'm sorry.
Are you asking us to, are you framing this and asking us to find insufficient evidence?
Yes.
Effectively because your client can't be retried, essentially, because of double jeopardy issues.
I mean, that's not exactly why we're asking for it.
Well, it's a more
because I believe that's the precedent of this court.
It's a more beneficial outcome, but it goes to a doctrinal question, which is, I think, important here, which is the reason an individual cannot be retried when insufficient evidence is found is because that triggers double jeopardy protection.
Right.
And in this unique fact scenario, does it make sense to apply double jeopardy principles when what really happened, what we all know really happened, is just a mistake in the charging doc?
Well, I think it's analogous to the exclusionary rule, where officers do something wrong.
Well, it might be analogous, but that's not part of our doctrine. I mean, we don't have an exclusionary rule on appellate remand. Do you see that?
I think State versus Lacey kind of does say that it's the prosecutor. This is such an important part of due process of our judicial system that it is important enough that the state act properly and do their job.
Right, which is why we always make them do it over. We say, you screwed up, do it over. And the only time we don't say do it over is when double jeopardy has attached. I guess I'm asking you to make your best argument for why double jeopardy attaches to your client here in this situation.
Because all the evidence of the underlying charge has been of what actually happened by the facts at trial have already been put out there. A determination has already been made. And
well, that's not true. If you look at the charge, there's no, the state didn't put on an evidence. That's your whole point. The state didn't put on evidence.
Right.
Of the charge.
Of that charge. Right. But all the evidence that would come from a filing, a refiling under the subsection has already been put before the court, has already been found, as I believe noted by Justice Biles, that he was found to have been convicted of violating a protection from stalking ordinance. And also it would prevent, I think it would impact his ability to work out another plea argument where it again recharged.
Okay. I appreciate you engaging in my prolonged back and forth. I'm sorry I took up so much of your time.
It's always a pleasure, Justice. Thank you.
Can I back you up to the statute itself again? In subsection A, you suggested that the elements, subsections A1 through 6 differ. Do they differ only in the type of protective order that's being violated, or is there more nuance to it than that?
I think the only nuance with that is, yes, they are each separate types of orders and how they can be violated. And it requires a different mindset or intent by the defendant to violate each one of those separate orders.
How so?
Well, if you have a protection from abuse, it's contact with the individual and knowingly violating a protection from abuse order. The other is completely different underlying criminal action, that of stalking. And It's to knowingly violate the order that has been imposed against you.
Contact's not necessary under stalking.
I'm sorry, Your Honor?
Contact's not necessary under stalking.
That's correct, Your
Be
Honor.
out on the street corner.
Yes, Your Honor.
So that's one answer to the question. There's a different way of violating different orders.
Thank you, Your Honor. If there are no other questions, I'll step back. Thank you all.
Any other questions? Wait a second.
Oh.
No, okay. Thank you for your argument, Mr. Webb. Mr. Obermeyer, you're reserved 3 minutes.
Thank you. Following up on Justice Wall's questions, I think there's 6 different orders that can be violated. I read that as what would be an option within means under the State versus Brown line of cases. That you don't have to have an different actus reus for the different kinds of violations. And if it is an option within means, then it doesn't matter that the complaint alleged a violation from a protection order versus violation from a stalking order. And clearly, there was no prejudice, and the appellate court shall disregard all mere technical errors and irregularities that do not affirmatively appear to have prejudicially affected the substantial rights of the party complaining. As to, I did omit to mention I had filed a 609 letter where this wrong subsection was filed in a Pennsylvania case. And the court says that that's not a due process issue. That's not a violation. And it depends on how the court frames it. If you frame it as a sufficiency of evidence case, that's one thing. If you frame it as a sufficiency of the complaint, it's a different argument.
Let me ask you a question. Let's say hypothetically that instead of the difference between A1 and A6, it was A1 and A5. 5 being violation of an order on post-release conditions. Would your argument be the same, that they're just options within means?
I think it would be the same. And I covered that in my initial brief of appellee. But so there's evidence at trial that it's a post-release order that's being violated and it's charged as protection from
Abuse.
I think it would be the same. I think I would have the same argument as long as the defendant is on notice as far as what he was charged with and what the evidence against him was, and can't show that this was a trial by ambush, that this isn't what I thought I was going to trial on.
Well, is that a factual determination whether the defendant was on notice? Because that's pretty different. Violating, especially if the person does actually, I mean, because what you're saying, this isn't just going to apply to this case. This is going to apply to all of our cases going forward that, hey, this is not sufficiency of the evidence because, all the evidence supported, the crime that we intended. But if in the hypothetical I gave you that this person really did have what was on post-release supervision at the time, that he violated a PFA?
I think it would be the same analysis whether or not he was prejudiced by that constructive amendment or that variance from what the complaint alleged and what the evidence presented at the trial was.
Right, but so then you're saying that going forward, insufficient evidence would be subjected to harmless error analysis.
I don't think that would be the holding. I think it would be if there's a different subsection and there's evidence and the complaint is essentially broadened to include another alternative means or option within means, that would be subject to harmless error. And I direct the court to take a look at State versus Turbeville. And there's a line of cases on that where charged with one subsection, convicted under another subsection of the same statute. It's the same crime. This isn't a forgery, false writing.
What
issue.
year was that? Was that before or after Fitzgerald?
It was in the 70s or 80s.
Okay. And then one other question. Bottom line here, just bottom line.
Sure.
We're going through a lot of, as we say, legal gymnastics.
Right.
When the bottom line here is the state just made a mistake. Why should we try to fit a square peg in a round hole to do all these mental gymnastics when the bottom line is the state made a mistake? Let's just hold them to it.
Well, I would, if you look at the statistics on how many cases are filed a year, criminal cases across the state of Kansas, it's a big number, I'm sure. You're going to have some errors on that.
And so
and-
the Supreme Court should, try to fix those errors, even if it messes up our precedent. I mean, it's just.
Well, but we have the statute saying if the complaint's deficient, the defendant should raise that. And we have the harmless error statutes. And sure, if the prosecutor, changed, in the supplemental
But
brief.
then that put the burden on the defendant? Why should the defendant have to do that? The state is responsible for charging the crime.
And if it's deficient, then he should raise that. Otherwise, he's had discovery. This person was in
But then you're
court,
going to notice, you're going to all this stuff that has to do with harmless error.
right?
Okay, I'm talking about you charged a crime, you did it wrong, there was insufficient evidence of the crime you charged, and now you're all the way up here at the Supreme Court saying, we made a mistake, and so can you do some legal gymnastics and figure out how to fix it?
I'm saying that that harmless error should apply on complaints that charge the wrong subsection of the case. If there's no prejudice in that situation.
Thank you.
And I direct you to look at that Pennsylvania case because it happens in other states also. But so for the reasons argued in this original and supplemental brief, there was no prejudice. He knew what he was charged with. He was found guilty of protection from stalking, so it's not a state versus right violation. And I'd ask that that the Court of Appeals be reversed. Thank you.
Thank you, Mr. Obermeyer. Thank you, counsel, for your arguments here this morning.